Welcome to the College Investor Audio Show, where we talk about the biggest issues impacting millennial money, from student loan debt to side hustles to building wealth. We will show you how to get out of debt so that you can build real wealth for the future.
Hello and welcome to the College Investor Audio Show. Today, California's Student Loan Borrowers' Bill of Rights. The law, AB 376, was passed in conjunction with some other consumer protections laws. In particular, the law gives California's newly created Department of Financial Protection and Innovation the ability to govern loan servicers, including banks, credit unions, and even the federal loan servicing companies. So here's what California's residents need to know about this new law. First of all, what is it? What's this Bill of Rights thing? It's primarily a new consumer protection law. The California legislators deemed the law necessary due to a perceived lack of federal oversight for student loan servicers. While the law is significant, it doesn't erase debt or change the terms of loans. Rather, it protects borrowers from loan servicing abuses that can make debt more expensive or more difficult to discharge in the long run. In particular, it legally requires that loan servicers would need to consistently act in the best interest of the borrowers. It is a first-of-its-kind legislation, and it makes it illegal for servicers to take advantage of borrowers' confusion over repayment options. In addition to barring abusive behaviors, the law establishes industry-specific standards for student loan servicing. It also establishes the right to punitive damages if a servicer fails to comply with the new standards. And with all these new standards, California's student loan borrowers may start to make more headway on getting out of student loan debt. Woohoo! So let's talk about some of the provisions, or the Bill of Rights, if you will. So they establish that servicers and lenders may not engage in abusive or predatory behaviors in regards to student loan borrowers. It delineates specific requirements around those rights. For example, servicers must provide accurate information about repayment options. Borrowers who could access flexible repayment options must be given accurate information about those options. Servicers must help borrowers avoid default. Wherever possible, borrowers will need to provide information about income-based repayment programs or other flexible repayment options to avoid default. Servicers and lenders must not be negligent in omitting important information. This is crucial. They must present all the important information about a loan and not misrepresent it at all. Servicers cannot take advantage of misunderstandings. Servicers are actually required to work in the best interest of borrowers, even if it means missing out on profits. Oh, my goodness. The law also establishes the rules of the road, or some standard practices that lenders must follow to retain licensure in California. Some of these rules include: servicers must process payments and other documents in a timely fashion. Payments that are received before midnight on the payment day should be marked as on time. Servicers must apply payments correctly. Under AB 376, servicers must apply payments in a way that minimize fees, charges, and interest payments. Servicers must also improve their record keeping. Student loan servicers have a reputation for poor record management. Maybe you've experienced this. These laws require servicers to keep up their records so borrowers can manage their repayment appropriately. Perhaps most importantly, the law provides consequences for servicers and lenders that break these Bill of Rights or rules. In particular, it provides an option for private lawsuits against student loan servicers. Borrowers who believe their loan servicer has broken a law may sue the servicer for punitive damages. And the law also applies to both private loan servicers and federal loan servicers. No kidding. So how can California borrowers benefit from this law? Well, borrowers who are up to date with their loans are really unlikely to see any benefit at all from this new law. Loan servicers may start to tighten up their practices, though. Overpayments will start to be applied in the best interest of the borrower. No more seeing 6 months of prepaid payments rather than a decrease in principal balance of a loan. Most servicers should offer quicker responses and also better answers when you call, and that's always nice. However, the real beneficiaries of this law will be borrowers struggling with loan repayment. Those borrowers will get clear answers about how to avoid default. Servicers will provide useful information about repayment plans and even loan forgiveness where possible. Borrowers who are misled about their options will have the option to sue their servicers for material and punitive damages. This law will not be an excuse for borrowers to miss payments, though, or mishandle their debt. Rather, it will provide accountability for servicers to act in the best interest of borrowers. So, what to contact if you want to learn more about this law? So California's Student Loan Borrowers Bill of Rights does not go into effect until July 1st of 2021. However, borrowers may start to file complaints on loan servicers through California's Department of Financial Protection and Innovation. Mouthful. Borrowers can also enlist the help of a bankruptcy attorney too, or even a consumer advocacy attorney to help with private action options. Well, in case you've been hearing about this new law, I hope that kind of clears things up and also maybe gives you some hope if you've been struggling a little bit to pay back loans or just completely confused about the process. This law is here to help. Thanks again for stopping by today, and if you want to find out more about this and tons of other stuff, you can check out thecollegeinvestor.com to find out everything. thecollegeinvestor.com.